Hi, I'm Sarah Ocampo, and I've been a probate attorney in Las Vegas, Nevada since 2003. The first question I get when someone schedules a consult with me for probate is generally, how long is it going to take in Nevada and how much is it going to cost? These are the main questions people have. And my honest answer is, it always depends. Lawyer answer, but it's true. It depends on a lot of things. I need to know more about the situation, the number of assets, and the value of the assets before I can give you an estimate of the time and expense for probate. This is because there are different levels of probate in Nevada depending on the value of the estate. So the higher the level of probate, the longer it's going to take and the more it's going to cost, of course. The lower the value, the less time it's going to take and the less amount of money it's going to cost. I'm going to go through the different levels of probate with you just so you have a general understanding in case you're ever in this situation. Level 1 is the set-aside probate. This is for probates that are very low value. Specifically, they have to be estates between basically $25,000 and $150,000 in probate assets that need to go through the court system in order for them to go to the rightful heirs. When an estate qualifies for a set-aside, the court process is very limited. You go generally to one court hearing. Your lawyer will go to one court hearing, and there will not be full probate administration. It's generally done within a couple of months tops. It's not a long process. It will take a very short period of time. Level 2, summary administration. This is for probate assets that are between $150,000 and $500,000. This is kind of the mid-level of probate. It's for a lot of people, they go through this process because their assets are in this arena. This is a little bit longer and it's going to cost a little bit more money. It is still streamlined, so it's not going to take forever. It is a streamlined process. It will require fewer court hearings than the higher up probates, and it typically costs less than the full-blown probate. These cases often take several months to get through, so be prepared for that. But again, it also depends on if there's any disputes during the process. The final level of probate, which is the higher level of probate, is called general administration, and that is for probates over $500,000 in assets. So that's assets that have to go through the probate process. This is for larger estates. Lots of times maybe there are multiple heirs, right? We don't know. And it does create more complex financial situations. It also requires more court appearances and it will take longer to get through. Usually, again, this isn't a perfect situation. For a perfect general administration, you're looking at between 6 and 12 months in probate court. However, it all depends on the type of assets and what kind of issues might come up during the process. What can make probate take longer? So even with these categories, like I keep kind of saying, timelines can vary depending, right? So probate tends to take longer when there is a will, but maybe we can't find the original. So now we have to prove up a copy of the will, or maybe there's a will and people are contesting the will. And so we have to have a prove up hearing for that. And that takes a long time and creates a lot of expense for everybody. Also, when family members disagree, they may start intervening and slowing down the process. This can also cause delays and create longer probates with more attorney's fees. We sometimes find that the property, the real estate, takes a while to sell in probate. That might prolong the process. Also, if you don't have a good agent and they're not doing the right things, that can also cost time and money. There can be additional delays if certain creditors file claims and maybe the estate doesn't agree with the claims, so they dispute it and there's a separate litigation commenced for the creditor. That might happen. That will cause more time and money. Sometimes beneficiaries pop up in the middle of probate that no one knew about, and then we have to investigate them and make sure they're true beneficiaries of the estate. So there's lots of things that can go on that might create some more time and money spent on probate, but for the vast majority of probates, they do move through the system quite efficiently and true to form. Next up, how much does probate cost? This is, of course, a huge deal, right? Let me start by saying that the attorney in probate represents the administrator or the executor or the personal representative, sometimes called the personal representative, of the estate, as well as the estate. So they are looking out for the administrator, and they're also looking out for the estate's best interest. Generally, attorneys are going to get paid at the very end of probate by the estate, and the judge will have to approve the fees. It's not like we get paid in the beginning or through the process. Normally, we're not getting paid until the very end, and we're going to be paid through the estate's assets directly, and the judge has to actually review all our invoices and our engagement letter and approve the fees before we ever get paid. Again, like I said, I have to speak in generalities because every case is different, but the lower level probates, of course, are going to take less time and cost less money. The higher level are going to take more time and cost more money. There are different ways probate attorneys can get paid. Some charge a flat fee, some charge hourly, and then sometimes they charge statutorily. I can tell you, generally, if we're in the very lowest level of probate, the set-aside estate, most lawyers, including myself, charge a flat fee for that process. For the next level up in summary administration, generally, including me, most lawyers are going to charge statutory rates. This is true also for general administration. What are statutory rates? Statutory rates are an amount prescribed by Nevada statute, and it's based on the value of the estate. So it's a percentage of the value of the estate by statute. The higher the value, the more the lawyer gets paid. The less value, the less the lawyer gets paid, which makes sense because the higher value estates require a lot more work and a lot more time involved. Why does it matter to get this done early, right? Someone passes away, I'm busy with a lot of different things. Why in the world am I going to worry about this right now? Well, there's a lot of reasons you want to do it right away. First of all, when someone passes away, no one has authority on behalf of the estate. The person is gone. So nobody has authority to get in the bank, to pay the bills, to deal with the mortgage, to deal with the house. None of that stuff, right? Nobody's around to do it. So step one in probate is appointing someone so that someone does have authority to administer the estate, to deal with the bank account, to deal with the house, to deal with the mortgage, to deal with all the stuff. Very important that we get to it early. I can tell you, the biggest deal that I come up with, that comes up in my cases, is with real estate. Someone passes away, they have a mortgage on their home, maybe their kids living in the house, and nobody's paying the mortgage. Well, then we've got a problem because it's going to ultimately go into foreclosure if nobody's paying the mortgage. If it goes into foreclosure, then it could be sold at a foreclosure sale and the bank could take it back. In that case, it's incredibly important to start the process early so we don't get into a foreclosure process and we don't lose the house, because most times there's equity in that home for the heirs. You want to preserve that equity, get into probate, and get it dealt with before it's too late. Why does getting guidance early matter? Similar to the question that I just answered, but getting guidance early matters because when someone's no longer there, nobody's taking care of their stuff. And when someone's gone, you want to make sure everything they worked for goes to the right people instead of going to creditors or just getting lost. So that's why it's important to get the guidance early and start the process as early as possible and talk to a probate lawyer. My name is Sarah Ocampo. I am at Ocampo Wiseman Law in Las Vegas, Nevada. We handle probates throughout Nevada. We also offer complimentary phone calls for anyone that wants to talk about it. It's usually with me. You can schedule them directly on my website, or you can call my office and you can schedule a phone call from there.